take the baton of introducing and then take things forward. Over to you, ma'am.
Thank you. Thank you so much, Vikas. My dear friend, Justice Roshan Dalvi, Shri Vikas, and all the participants, learned participants. It is a great pleasure, as we have seen last week in detail the provisions of the POCSO Act as to how comprehensive and well-intended it is, how it fills up the lacuna in law and creates the mechanism for making the investigation and trial process child-friendly. We have to remember that, however, the law legislation may be even the best one, it is not sufficient unless it is implemented in its spirits properly. The law, after all, is a dead letter. The life is infused in it by those who operate it, especially in a socio-legal legislation like the POCSO Act, where we are dealing with the most vulnerable class of society, the children of tender age, and those who are subjected to the most heinous of all the crimes, that is sexual abuse. It is of utmost importance that the stakeholders in the system, maybe the investigating officer, maybe the police officer or the judicial officers, deal with them with sensitivity. And this importance of the sensitivity has been emphasized by the Apex Court from time to time, way back in the case of Bogin by Hardwara, which was in the year 1983, thereafter in the case of State of Punjab versus Gurmeet Singh of 1996, then of 2009, Nipun Saxena versus Union of 2019, Nipun Saxena versus Union of India, and the latest decision of Aparna Bhatt versus State of Madhya Pradesh, which was of 18th March 2021. In all these cases, the Supreme Court has emphasized on the sensitivity because, according to Supreme Court, and everyone will also agree that without the sensitivity on the part of the stakeholders, especially the judicial officers, the advocates, and the police officers who directly come into contact with the child, there is every likelihood of justice becoming a casualty on account of technicalities. I mean, there is very wonderful quotation of Justice Krishna Iyer in the case of Kishan Lal versus State of Haryana, that was in the year 1980, AR 1980 Supreme Court 1252, wherein he has said that it is the sensitivity on the part of the police officer or judicial officer, which is a far better statutory armor against the gender outrage or offenses against the child or the woman, than the long clauses of the section with all protection written to it. So my friends, it is the sensitivity which is of paramount significance. And in this session, we are really dealing with that part of it, because it is the sensitive handling of these cases which will prevent the child victim from being the subject of secondary victimization or adding trauma, which he has already undergone. Here, it is also important to remember that a judge has not only to be sensitive, but innovative also in its approach, and its approach should be totally justice-oriented. And I'm really happy and glad and privileged to share with you all that today's our key speaker, Justice Roshan Dalvi, is one of such a rare judicial officer who keeps on innovating. And she has, I'm happy to share again, that she has adopted all the child-friendly techniques in her handling of these cases even before the POCSO Act came into effect. And therefore, it is very important to know how she had implemented these provisions, which ultimately found place in the POCSO Act. So like all of you, I am also eager to hear you, Roshan. And therefore, this is, instead of taking more time, I would really hand over the mic to you so that you can enlighten all of us. And I must say that I am also eager to learn from you. Thank you, Roshan, and hand over to you. Over to you.
Thank you, Shalini. You are very kind. And hello, friends. Good evening. Now you see, today we are going to deal with the subject of the most fragile and tender population of our country, our children. Satyarthi has said justice for every child. Now, he means justice in the entire country. But we are under the portals of justice temple. And therefore, we are most governed by this phrase, justice for every child. Somehow, people feel that justice comes only from the judge. It is not so. In many cases, which require sensitivity, it is required of everyone. Only if a judge is sensitive, but the other stakeholders are not, she or he can do very little. And when we talk of other stakeholders, we do talk of the police, the prosecutors, the medical officers, and the judicial officers. Now, medical officers, of course, to a very little extent, because they come into the picture only on one day. But all of these people. But I would say that this sensitivity must extend also to the lawyers. You don't become any the less a lawyer because you are not sensitive to the needs of a child before you. We all have children, and we all know how our children are growing up. But there are millions of children who are not so lucky, who are not so fortunate to grow up within the protection of the family, the extended family, the outside resources like the schools, etc. And there are a lot of crimes perpetrated upon these children. Now, I will assume that you are not a prosecutor, but a defense counsel. And even then, the sensitivity which is required is of two parts. One is to be sensitive, and one is to empathize. That means if I was in that position, what would have happened to me? What would I have expected? What would I have done? These two things, sensitivity and empathy, I would call sentipathy. It's a portmanteau. It's not in the dictionary, but it's not a slang word either. So this sentipathy which is required is of everyone. And why only lawyers? Even the court staff, for example, our peons, our sheristadas, our legal officers, even if they are insensitive to the child, it hurts. They cannot speak anything. It is like prevention of cruelty to animals. Because why? They cannot speak. They cannot shout like you and me. But we have to keep in mind that these are God's children, our country's children. And in fact, why even our country's children? The world's children. Because we can work without boundaries. There are doctors without boundaries. You can have our system for children without boundaries. I have seen children's cases in England, in Canada. And I've seen how differently they have been treated. One judge sat at an angle and took the child in his lap while the evidence was being recorded. Was he any the less a judge? Was he prejudiced against anyone? No. He wanted to treat a child as a child and not the child only as an adult witness. There lies the nobility. Nobody at all raised any eyebrows or any objections to the judge's venture. Of course, that was the case of a drug cartel. And a child was sort of, involved in that. And therefore, he treated the child with the protection that the child deserved. Now, of course, a lot of things have been done under the Sexual Offences Act, which came into UK from 1976, and under the Victims of Crime Act in America. And now we have adopted that after the Palermo Conference into our POCSO. Okay. So I will share with you my presentation, which is on this theme. And I would say, treat a child as a child. Today, while I'm giving this lecture, if a child walks into one of our rooms, what would we do? If we are in one room and all of us together, what would we do? I would stop giving the lecture. You would stop hearing me. And you would just talk to the child and say, Beta, mummy kahan hai? Is that some breach of protocol? Is that we are prejudiced against anyone? No, that is the decorum required for a child. And of course, we are not going to do that in the court. But something like that we can do, which I have done, and I think all can do. And of course, Shalini also has done a lot of all those. And I will be giving you some examples of how those things matter and how if you don't do that also, it tells on the hurt and trauma of the child. So if you give me a minute, I'll share my presentation with you. Can you see my presentation? So as we first enumerate the crimes against children, what we see is, oh God, that is right. Okay. So these are the various crimes which are perpetrated against children. Keep seeing. Now that you see, we have got these crimes right from at least 1860 as crimes against society, which are against our children also in the IPC. Okay? And you will be knowing how the crimes in respect of marriages, in respect of miscarriages, which is abortion, and they are now under various other acts also. And there are numerous such crimes, and I've tried to keep everyone in sight. Okay. Now under POCSO, we have specified crimes. That is the sexual assault, aggravated sexual assault, penetrative sexual assault, aggravated penetrative sexual assault, sexual harassment, and pornography. Okay? So this is what you know. But so far as the cases that come up before us are concerned, what we know is the two tests that we must always apply in our minds. And this first test is the test of lesser numbers, greater attention. What do we have? We have a lot of children at certain times and places, and they don't get the requisite care and protection. These are neglected children. Now, if you see at home, there may be a home with one child, there may be a home with 8 children. And the care and protection is completely different, even arithmetically. It is very good to say that a mother loves all the children, but she cannot devote her time to all the children. These are the children who are vulnerable children. They are the real targets of sexual offenders. And those sexual offenders may be in any of those crimes that we have seen, including child trafficking. They may traffic the child and take them away. Now, if there is just one child, essentially, even if there are 2 children, they are better cared. Otherwise, what happens is the houses are small, the children are one too many. The mother says, "Jao bahar jaake khelo." Children are outside, they are pried upon, they are taken into other people's homes or huts or whatever, and then they are sexually molested. That was one such case before me, and how I conducted that trial, I will be telling you presently. In schools, it is the same thing. If there is a municipal school with 130 students in a class, the teacher cannot give the same kind of attention that the teacher can give when she has 28 children in a class and the student-teacher ratio is much better. Similarly, in the countries of Asia, Africa, etc., where there is a lot of population, there are more vulnerable children. It is not that in other countries the children are not vulnerable, but they are more vulnerable. The degree is more. And of course, just like in our courts, if the courts are packed to capacity with work, then naturally the judge cannot take care of all the matters. So when such a matter comes up before us as lawyer or as judge or as police officer or prosecutor, we must feel what is wrong there. Is this a case of lesser numbers, greater attention, or greater numbers, lesser attention? Has this child got lesser attention so that the child has become a victim in this case? That is the first thing that must come to us. The second test is the test of the 3 R's, which was given by the Boy Scouts of America many, many years ago. And that is to recognize that there is this problem. Okay? Now, we generally tend to feel that, oh, this problem never exists here. It never happens in my backyard. It never happens in my house, in my family, in my society, in my country. We are wrong. It happens in all the societies and in all the countries because some or the other vulnerable children are everywhere. Neglected children are everywhere. Okay? Now, they may be poor children or they may be rich children. Rich children generally are preyed upon by their family members, by their drivers, cooks, any of those kind of things. Poor children are preyed upon by their family members, traffickers, transporters, all of those kind of people, because they are sold or they are abandoned. Okay? The second R is resist. The child must resist. Every child understands a good touch from a bad touch. So when the child says, gee, oh no, it must be respected. Of course, the trafficker or the attacker is not going to respect that. But if the child, somebody has got into the child and the child reports to the mother or the father, quite often they say, oh, ऐसा बोलते हैं कि ऐसा नहीं बोलने का. ये तो अपने चाचा जी है. You know, that way. So the child feels betrayed. The child doesn't have trust. The child cannot speak to anyone. And this Chachaji knows that he will be able to do better and better at every time when he gains access to that child. So we must understand that the child must resist and teach the child to resist. That is an awareness program. And of course, you can't do it when cases come to court. Those are the children without which the society has failed. And therefore, they come to our courts. But before that, that is done. If they cannot resist, and therefore we must think that this is a child who unfortunately could not resist that sexual assault. Okay? And report. We must report every crime. And more so, we must report crimes against children. And now under sections 1920, there is a specific legislative mandate that if you know that something is happening, you must report. So if you know that there is this thing happening in your family, you report. In somebody else's family, you report. Because then at least another child will not be similarly assaulted or abused. So therefore, we have these partners in our system. Who are there are two partnerships. One is of parents, teachers, friends, and NGOs or the counselors. Okay? So these are for awareness creation, for the victim's needs. Before a child becomes a victim of that kind of an attack, we as parents, teachers must understand this is the problem, watch out for it, accept the child's speaking, be in such a position that the child can confide in us. Okay? Now, if these people have failed, because everywhere sometimes there is failure, then the case happens because an offense is committed. And then come the police officers, medical officers, legal officers, and judicial officers. And of course, now under our system also, the criminal justice agencies, which we call NGOs. Now, they require an attitudinal change. Not only that I am appearing for this man, therefore I will do everything only for this man, forget the child. Not only that I am a police officer, I am in command, and therefore I will berate the child. Not only that I am a medical officer, I have no time. So I will tell the child, "Acha, kya history hai, bolo." Not that way. And legal officers would be both prosecutors and the defense counsel. The responsibility, obligation, and duties that we have to the child is not whether we are appearing for the state or against the state, but it is that we are appearing in the matter of a child to bring the truth before the court. And of course, if there is no truth, as a defense counsel, you bring that before the court. And I will be sharing with you one of my cases where there was no truth in a child's statement and how that came to be. Then, of course, judicial officers, that is judges, who primarily are on the top of the ladder, and therefore they really are the captains of the court. And therefore they can always have a sway over the case that they conduct if they conduct it with all sorts of decorum as well as firmness. The criminal justice agencies are the agencies that work within and outside the court system. Now we have the guardian ad litem or the NGOs or whatever, by whatever name called, under our POCSO. So there is child representation. That representation is by a lawyer or by an NGO, who is generally a lawyer also by at least profession. So they can then mold the court proceedings to show the court what the child has suffered and how that must be to achieve the state goals. Now, what are the objects of this partnership? The two partnerships bring about a culture change in the society as well as in the courts. Now, there must be several men who will feel very, very strongly about child sexual offense. In fact, we are told that even prisoners, even convicts in jails, they feel that a convict of a child sexual offense is different from other convicts. They themselves then sexually violate such an offender. So therefore, they also require a separate protection under the Prison Reforms Act. And therefore, men talking to men makes a lot of difference. And men also must feel the same way. It is not only because we take women and children on one side, even under our constitution, that only women must be sensitized. And it is not so. Many men are far more sensitized than many women. So we have MAVAO, that is Men Against Violence Against Women. That is an organization. They abhor this kind of violence. And the second, the USA, we have the VAWA Act, Violence Against Women Act. So this women is women and children, of course, because if she is under 18, she is a child. Now, these anti-violence messages can be brought out by the government, by, say, the church or the temples or anything like that, by community groups, which are NGOs, and at workplaces also, where there is sexual harassment and those kind of offenders come along. So now we go to the legal provisions, actually. First are the international covenants. There are one too many. I've taken out the most important for us. The initial one, the Universal Declaration of Human Rights, specifically speaks of rights of the child. The Covenant for the Rights of the Child itself, under clauses 17, 18, etc., specifically say how children must be protected against sexual or other onslaught. Convention for Elimination of All Kinds of Discrimination Against Women is thought to be only against women. But even a woman of 15 years, for example, is a child, and therefore she would have to be protected as a child under that covenant. And similarly, covenants against torture and cruel treatment, especially when there are conflicts, armed conflicts and wars, women and children are the worst sufferers because they don't only come to them as enemies, but they come to them for sexual assault. Then the International Covenant on Civil and Political Rights, which otherwise we would feel is nothing, has got clauses for children. And the Palermo Protocol is the main thing which brought into effect, ultimately, our POCSO. Now, there are those national legal provisions. In our country, we have the IPC from 1860, 150 years before our constitution. And under the IPC, though women and children are not separately treated, and it is a kind of a unigender law, but there are provisions for women and children. And that is right from, say, female, I told you all of those offenses, right from female feticide, infanticide, femicide. And in between the infanticide and femicide, you will have incest, sexual assault, outraging modesty, and then sexual harassment, pornography, abortions, miscarriages, offenses relating to marriage, etc. Okay, so all of these were there. And as much as trafficking and slavery was in our IPC, then came our constitution. It granted special status to women and children under Article 15.3. And therefore, there are now various laws specifically made under Article 15.3. Okay? So the Immoral Traffic Prevention Act from 1956 that we have, the Bonded Labor Act, that is for children in labor. They are also assaulted. The Domestic Violence Act, which of course applies to women. Then Child Labor Prohibition Act, which applies to child labor. POCSO Act is the one we are dealing with essentially, which we deal with Juvenile Justice Act, where a child is in need of care and protection, as well as the delinquent child who is on the wrong side of the law. And one state, Goa, has got a separate Goa Children's Act. Now, all of these legislations, international and national, call out these rights for the children. We fail to understand this when it comes to court cases. We only deal with one law, the IPC and the POCSO. But all of these rights are right against exploitation. Now, for example, in the Constitution, which gives fundamental rights, there are two prohibitions, only two prohibitions, and they are in the chapter on fundamental rights. One is the prohibition against untouchability. We are not dealing with that today, but there may be untouchable children. They are not untouchables, they are Harijans. Gandhiji called them children of God. And the second exploitation is the exploitation against trafficking, which we are very much concerned with in this lecture and in these kind of matters of POCSO or ITPA, which come to court. Because under Article 23, there is a right not to be trafficked, because human trafficking is a prohibition under our constitution. They say human trafficking is prohibited. Okay, so this applies to children as well as, of course, adults in some few cases. They apply to girl children as well as boy children. So we know that there is a right against exploitation. There is a right to information to the child, the right of representation and hearing, which is now given even under POCSO specifically, the right to assistance, which means protection and assistance of NGOs and other court officials, the right to privacy and confidentiality, which is now in our IPC, in our POCSO, JJ Act, everywhere. Protection and safety is against whoever is the offender. Then, of course, the right to speedy trial, which is there right in the Constitution. The right of rehabilitation. And in some cases, when they come from other countries, like, for example, Nepal, Bhutan, Bangladesh, whatever, repatriation is the right of the child. So ultimately, so far as judges are concerned, when we pass the ultimate orders, we have to seek and think about the child's rehabilitation and repatriation if the child was trafficked and has no parents or anything. Then the right to compensation. Now, of course, every single case, every single criminal case from 2013, 10 years ago about, the Justice Thakur's judgment in Ankush Shivaji Gayakwad versus State of Maharashtra says, you must consider the compensation. That means even if you are not going to grant compensation, even if it can't be given, you must consider that aspect and say now there can be no compensation. Not that it is always followed, it is not. The right against forceful deportation. That happens to children who have been trafficked, who cannot really speak, and they have been trafficked from other countries, and they are forcefully deported. Now, if we are going to work without boundaries, if we are going to have sensitivity for every child that we come across, then even this deportation cannot be forceful. You have to see where the child can be now protected and then deport the child. Then the right to sue the traffickers for compensation. That is an additional right against traffickers who are very well-off parties. Now, in our sensitization for this law, substantially, what we consider is the impact of that offense which has been committed on the child. I would give these as the most important impacts if you can read it, but there are many more. So the psychology is impacted and destroyed. It devastates life. It leaves a bitter shock. The child is disgusted. There is disbelief, suspicion, helplessness, frustration, anxiety, loss of security. The feelings of guilt, unfortunately, so wrongly it is that a child herself or himself feels the guilt. It is so wrong, but it is there. Fear of disclosure. How will they do it? And the confusion that comes in our justice system. And that leads to what? What we call re-victimization. So when we are dealing with our children, as a child witness, as a child victim witness, whichever way, we must know that there is re-victimization. Now, this victimization is for police investigation, but now under the POCSO, these sections give specified rights. Under sections 24 and 25 of POCSO, there is a specific way of investigation which police officers are now constrained and enjoined to do. There is a Mahila and Shishu desk in every police station, or at least it must be. And then there is the 164 statement which is recorded. So that is an added provision for when, but when, if not done sensitively, it results in secondary victimization or re-victimization. Then after the investigation is done, the modicum of investigation, then the child's medical report has to be obtained. So the child is sent to the hospital and the medical examiner, the doctor, will have to examine the child. Not many have the time, not many are sensitive, not many are attending this lecture. And therefore, there is re-victimization even there. The tests which should not be taken, which the Supreme Court has said, which the United Nations has said, the two-finger test is continued to be taken. History has to be written down, and therefore they ask the child instead of asking whoever comes with the child, because the child is the patient. And there is re-victimization. This is dealt with under Section 27 of POCSO and under 164A of IPC. Then, of course, the most important re-victimization, which goes on from day to day, minute to minute, and year to year, because for 3-4 years the matter doesn't reach, is the court trial. And the child is re-victimized. In one case, it was said that this daughter, that was the case after Nirbhay, and that was taken to be the other daughter of India. She was re-victimized by the law players or lawyers. She was asked for re-examination and all that until the Supreme Court said nothing more. So now, what is the substance of this act that is meant to be under its objects? The substance is that there is a dilemma for the child. Two big dilemmas. One is the child versus adult syndrome. Everyone is an adult in our court. Our court works with the adult at the center stage. But we require to have a child-friendly atmosphere under our legislation. Do we understand what that is? So that child-friendly atmosphere is that we treat the child not as an adult, but as a child, as we treat any other child. So we treat that witness or victim a little differently. Not that we are going to only convict in that case because there is a child. We don't. In most cases, we acquit. I will tell you of a case where I have acquitted honorably, not even on benefit of doubt, because that case failed. But after giving the child all that was due to her, I'll tell you about that. Victim versus accused syndrome is the other syndrome in the court. One side, there is a victim. On the other side, there is an accused. The accused has got all the rights. He is entitled to all the rights. And he has got all the rights. We have come of age. Under Articles 21 and 22 of our Constitution, we have given all the rights to the accused, which is what it should be. But that doesn't mean that to pander to the accused, we forget the victim. That is the point we are making. And therefore, there are these things which have come about in the Western countries many, many decades ago, and now in our POCSO. So victim representation. And I would say all lawyers should rejoice. Actually, there should be representation for all victims of all nature. Even in a murder trial or a dacoity trial, why should the victim not be represented? The victim is the complainant or the complainant's heir or whatever that is, and is very much interested in bringing the accused to justice. And therefore, there should be representation. And if the representation is there, lawyers will have double the number of work that they are having today. Because now lawyers are appearing only for the defense, and there are few prosecutors only for the state. You can have a prosecutor for the state, an accused, a lawyer for the defense, and a lawyer for the victim. But at least for children under POCSO, taking from the Palermo Conference, taking from the Sexual Offences Act and the Victims of Crime Act, we have got under Section 14 representation for the victim. It may be an NGO come lawyer, it may be only a lawyer, it may be both. There can be two people representing the victim. Then there is victim support. Now, Section 33 speaks of all the various things in the trial, but 36 and 37 are what contact the victim must have and what contact she must not have. So contact with the prosecutor is very important. The prosecutor is going to ask questions to the victim. And every time, wherever there is going to be cross-examination or examination, there is a conference with the lawyer. So why should a child not confer with the person who is going to ask the child questions? There is nothing like you're going to brainwash the child or indoctrinate the child. But the more important thing is no contact with the accused. And how that can be is a matter for that substance, of sensitivity. Then victim protection, as under Section 37, various things that you have to do, and victim participation, which is actually not even in our POCSO yet, but under the Victims of Crime Act in America, what they say is the victim's right to speak, the nation's responsibility to listen. It's such a telling phrase, which is the object of that act, that we all must listen to the children. They may have to say many things. And this right is given at 4 stages. The stage of bail or remand, then the stage where the trial begins, the stage of decision, and ultimately the stage of whatever is the rehabilitation or anything. We will deal with those 4 stages also presently. But now we are coming to a stage where there is an offense committed. Now, how do you treat a victim and an accused? The accused, of course, has to be arrested. He will be interrogated by the police. Then thereafter, the police will apply for remand and the accused will apply for bail. Generally, in cases of trafficking and sexual offense, it is not prudent to just enlarge the accused on bail because he may go out and do this to the same child. He may do it to other children. This offense is very prone to repetition. He will also intimidate that child. So it is very prone to intimidation. If it is a trafficking case, then it is against the fundamental rights of the child. And quite often there is violence because you can't take the child by consent and very happily. And therefore the child is physically, sexually violated. Now, if these 4 aspects are there, should judges grant bail? The answer is simple no. But if in some cases bail is granted, it must be on stringent conditions that at least that child is not brought into contact with that accused. Now the victim, especially a victim of trafficking, a victim even of one sexual offense once committed, has to be rescued from that position of society. And then she must be interviewed by the counselors, or even he, if he's a child, must be interviewed by the counselors. Now, this takes a long time, and counselors are very sensitive people, unlike lawyers and judges. So they know that on the first day, the child is not going to say anything. It will take too long, and again repetitive sessions and various carrot and stick policy, etc., for the child to open up, even for the age. Quite often children are indoctrinated, they're extremely traumatized. I showed you that impact on children. And then from the interview, you can call out. Now today we have the CWC. And the CWC requires the same kind of sensitivity, because all of those victim children are brought up before the CWC. And they will have to see what has gone wrong with them. Now we have the kinds of these victims also, children, verified minors. They are definitely below 18 years. Quite often we feel this girl is about 14 years old and she says she's 19 years old because she feels that she will be let off or any such thing. Or if she is trafficked, then those traffickers have inculcated in her mind, indoctrinated her to say 19 so that at least they have not committed offenses against children. Some are possible minors. They might or might not be minor. Prima facie, they may seem minor, but we have to find out. The court will have to find out. The defense counsel as well as the prosecutor must show the court the relevant evidence. Some are verified majors. They are above 18 years. They are not children. They are not minors, and therefore they will proceed in the usual legal system. Now, for the proof of age of especially these possible minors, what happens? The first is the birth certificate. The birth certificate is a public document. It has got a presumption of its correctness. It can be just tendered across the bar and can be accepted. But the school living certificate is a private document. Of course, now the school living certificate is accepted under our laws, but it has to be proved as a private document, especially if the judge feels that this girl is or this boy is a minor, but the accused insists that he is a major and brings this school living certificate. How will that be proved? The headmaster who gives admission to the school maintains a register. The certificate is a private document. There is no presumption of its correctness. That private document has to be corroborated with a substantive private document, which is the register. And the register will show all the entries. So if there are any entries which are not found, or if they are interpolated, we know that this certificate, which is a school living certificate, is false and obtained falsely. That is very important to consider for whoever is appearing for the child or representing the child. And of course, the medical opinion, the phosphorus test, etc., which comes later, and there is a margin of error. Now, with all of these things also in our justice system, we have got certain roadblocks. One is the number of cases, all the cases which are not reported. There is nothing we can do in our criminal justice system. We have to report, but they don't report. The number of cases are not pursued even after they are reported. There is just no evidence brought. The victim doesn't come. Other things don't come. The mudde mal is not brought. There is little that a judge can do. Then there are some child witnesses who are tutored. And this is where I would like to share my experience with you. I had a case of incest. She was a 16-year-old girl. And I was really agitated that it was a case of incest. The father was in custody. He was working in Dubai. He was, of course, taken in custody when he was here. He used to come for his holidays. He was estranged with his wife. His wife was living in that same locality. He had 3 children. All the children were going to the husband's house and the wife's house intermittently anyhow. It was something like a row house. There was something down and something on the mezzanine floor. The children and the father used to sleep on the mezzanine floor. And the drawing room, kitchen, whatever was down. Now this child, because it was a case of incest, I said, I will have this in my chamber. I called the prosecutor, the defense counsel. I put the child in the center. I told her this is the last time she will be telling me the story, etc., etc. I told the accused to come sit behind the child. And I started hearing her case when she wept. So I realized, my God, what trauma. It has been so many years. Even then, she's recalling all that evidence. This is secondary victimization. Then came the cross-examination. And very nicely, politely, simply, the advocate was doing the cross-examination, which is not quite often the case. And the point that they were making was that this case is false because the child has been brought as a kind of a pawn by the mother who is estranged. In the meantime, the husband had remarried. He had a younger wife. Immediately, the case was filed. He was arrested and he could not go back to Dubai. His wife was living there. 3 years had passed from the time the mother was estranged, and the children were always with the father and going to the mother also. And the father was sleeping with the children. Nothing was happening. There was no such case. And he said that I was maintaining my child also. And he showed me the bank statements of telegraphic transfers that were made from Dubai. And then he showed me the marriage certificate, the Nikah-nama. And he said, and the lawyer asked me the question that for 3 years he didn't do anything with this child. Why will he do that after he gets another wife? And I came to learn from the entire evidence that this child was tutored, the case was false. And I acquitted him honorably. So this was a defense lawyer having a good case, behaving well, as I told him, coming to my chamber, sitting down, cross-examining, as I told him. I was referring to Shakshi and Gurmeet Singh and all of those cases. This was, of course, well before POCSO when I was the sessions judge. And I acquitted him. So you can always bring the truth before the court. Now, some witnesses turn hostile. And there also there is a substantive law, the judge made law. Even if the child has turned hostile, it doesn't mean you throw away the entire evidence. You take that part of the evidence which is okay, and then you take the rest of the evidence, put it together and make up a whole picture. Now, this also happened in my court once. The child was assaulted. The child said, he came, he did this, etc. He pained me, etc. And then she completely stopped. She didn't cry and she didn't speak. And she could not go ahead. Okay. They said she has turned hostile. But the neighbor came and gave evidence that when this child was taken in the room, the child was screaming. It was in the next hut. I was living in that hut. And I and other neighbors went and banged on the door. And the accused opened the door. And he was in his undergarments. And the child was crying. Now put 2 and 2 together. The child could not say only that much. Is there any law which says that you cannot take this evidence as a whole? We always read the document as a whole. We have to read also the evidence as a whole. And not only the evidence of one witness, but of many witnesses if that is required. And that is how we can take care sensitively about a hostile witness. Not all cases, of course, come up that way, but whenever they do. Then some cases are doctored, just the way I told you that there may be disputes of property, etc., and a child is put up like that. And that can always be seen by documentary evidence. There is no need not to treat a child kindly, but there is need to see the document and then do justice as per what the document might say. And of course, sometimes there is collusive investigation. The police will side the offender or the trafficker because he is corrupted and not bring things to light. I will tell you one case of trafficking, which is not by me. It was in Calcutta. And I was told that it was a trafficking case. After many years, the child was summoned. She was taken to the court and she was shown an old woman. And that old woman came to her and told her, "Mujhe maaf kar dena, meri bahut badi galti ho gayi." So they were just wondering, what is she saying? The NGO who went with the child. And the child said, "Who is she?" The child said, "She was a cook in our brothel." So they were wondering why she came. but she happened to be, and they did not know because papers are not given to the complainant. And that is an insensitive approach in our justice system also. They were shocked to see that this old woman was the only accused. The child narrated the entire story of how she was trafficked, how she was rescued, how this NGO has been protecting the child and providing for the child. And then when she had to identify the accused, she naturally said that she is not the person. So she was acquitted and the case was closed. But a sensitive judge would further say, make further investigation and find out who is this accused who has not been brought before the court. Of course, after many years, it is even more impossible to get that accused. But you can't just close the file if you are a sensitive judge. And if you are a sensitive prosecutor, you have to say proceed. There is a provision under the Evidence Act also, 319, etc. And you find out and show that this investigation was collusive. So this is how we have to see the objects of POCSO. What is the objects? The object is to prevent inducement to engage in unlawful activity. Now, this unlawful activity is unlawful physical or sexual activity. So all of these offenses that we are talking about. Exploitation for prostitution and sexual practices. So everything is covered in that. The sexual. Maybe infanticide, maybe feticide is not really coming within the provisions of POCSO. So if you take it in an extended way, that also would. And of course, exploitation for pornography, which is quite different, and cyber offenses now. So when we have got, please keep in mind that the objects are these. The object of POCSO is not to harass every single child who falls in love, who goes with a boyfriend, who lives with a boy, or any of those. There is an offense, of course, called statutory rape under 376 of our IPC. That is there. It has done a lot of damage. It has done more harm than good. But I do not see how those cases can ever come under POCSO. Because when you are living together, for example, the girl and the boy run away. It is not an unlawful activity at all. They are living in one room. It is not an unlawful activity. Only if they have sexual intercourse, then it becomes an unlawful activity under 376. And unless that is proved, the actual act is proved, the act of going away is not. So you can't say that because they were together, there is definitely rape. Only that has to be proved. And if the woman or the child says yes in the court, then it will become an offense under POCSO, if at all, because she is under 18. All these offenses would not come there. And strangely, you will find that all of these cases are, say, 363 and 376, along with POCSO. So the child is kidnapped, taken away by the accused. Now, who is this accused? The accused is also a young boy. He's a young man. He will be going to college. He will be going to work. He is not an offender. He's not going to do this to anybody else. He's just having an affair with a child, which we look down upon. Because our society has not matured, our law has not matured as much as our society has. Today, 14-year-old, 12-year-old children go and live together for a couple of months. They say, no, we want to. And there is consent. We don't say that rape is only sexual activity without consent. That is our problem. And therefore, all these POCSO courts are brimming to the capacity with those kind of cases. And the real cases of sexual offenses like prostitution, like sexual practices, sexual assaults, rape, etc., do not get priority. Now, if those cases go away from POCSO, then all of the other real POCSO cases would get priority. And we will deal with what is priority and what is that also, and how that substantive law must be sensitively considered a little later. Now, under the features, reporting. Reporting is a mandate. It was always there. It was understood. But now under sections 19 and 20, if you come across, you have to report. Now, if suppose a boy and a girl are staying together and you come to know of it, can you report that offense? I would say no. There is no unlawful activity. There is no exploitation for prostitution or any of the sexual offenses. We don't know about what is happening. We can't presume anything. So there is, to my mind, no need to report. But suppose you come across a case where a child has been screaming and nobody is listening. You go and you report that offense. You are duty bound to report. If a doctor comes across a case, for example, under PCP and DT Act, that this is a child, she is now pregnant, she wants to have her fetus aborted. It cannot be done under Section 29. Others could be arrested. Only the child need not be arrested, etc. But it is an offense. Must she report? Yes, she must report, because then she will protect that fetus also. So some doctors have got this dilemma. Under the medical code, they have to maintain confidence. This confidentiality would extend to any case of any crime also. But under POCSO, they have to report. Now, when will they report? If a person comes and says, my daughter has been kidnapped by somebody else, you report that crime. No, the doctor need not. But if somebody comes and says that, oh, she has been sexually violated, please check her. She will be having to report that crime to the police, and then the police will tell her to make a medical report in the case after it is done. So that is how I would read it sensitively. Then a false complaint. Of course, like I told you in my case, if there is a false complaint, then that is prohibited, and therefore there will be a separate, this thing, I think it is 6 months. Investigation procedure and trial procedure are laid down. You have dealt with that. Justice Joshi has dealt with that last time. These are all towards sensitivity. And there are 2 presumptions. And mind you, this is not conviction. This is not conclusive evidence. This is only presumption as to the offense and as to mens rea. So therefore, it is a rebuttable presumption, and it can be rebutted the way it was done in the case which I told you. So then you find, no, there is no mens rea. But when a child gives a statement in court, she has prosecuted that offense. She comes to court and gives her story. That's it. Thereafter, the court has to presume, yes, the child has said that, it must have happened. And then if the accused rebuts it, fine. If the accused doesn't rebut it, there would be conviction. Now, for this, there is this requirement of the criminal justice system: infrastructure, interpretation, and sensitivity. Infrastructure costs a lot. We, as a country, is somewhere in between. The West has got a lot of infrastructure. Many of the African and other Asian countries have much less than what we have. So, what is this infrastructure which is required? We may or may not have it exactly as the West has it. Victim support centers. Now, in the West, these are like 3-star hotels. As soon as an offense is committed against a child or a woman, she is taken to a victim support center. She is there for 15 days, 1 month, as long as she wants to be. The police will come and record her statement. The audio recording or video recording is done. It is sealed and given to her, and the police keeps one for the defense counsel. There is no evidence in chief. Then there is cross-examination only on this. And in this center, the medical examination takes place. If she has got trauma, she gets counseling help, etc. We have Shishu desks. Now, the Shishu desks have to be manned by sensitive police officers. And if that is done, they work with NGOs. There are all sorts of dedicated NGOs in our many cities, especially in my city, and they render yeoman service in trafficking cases, in sexual abuse cases. We have to take their support. Quite often, they take the child. If they take the child is fully supported. Then victim examination suites. So when she is examined, and that is not by the court, by the police officer, there can be those suites. Now we have got at least the magistrate's examination, and that must be done sensitively. We don't have these suites separately. But video recording of statements and video recording of evidence becomes different. If there is video recording, and now especially thanks to COVID, when we have got all these sorts of webinars, we can always have these kind of things recording on video, where the child's trauma could be minimized. So that is the infrastructure. The interpretation is the interpretation of the act and the interpretation of the judgments, how best the judgments can be interpreted. But sensitivity is the most important thing. It is on a zero budget that we have it. And that is, I would put it in two parts: court climate and courtroom conduct. So these stages which require sensitivity are these three stages. The stage of bail. We must understand that once a bail is lost, everything is lost. The accused can abscond. Many of the traffickers, brothel owners, brothel keepers are absconding and we don't get them. So at the time of bail, the hearing must be of the victim, the accused, and the state. The victim under POCSO will be represented by the NGO or her lawyer. Accused and the state, of course. Then at the stage of evidence, which is divided into two parts, recording of evidence as per section 33. I don't have to go into it because that is done last week. And appreciation of evidence, again, which is the latent evidence that you must appreciate. Now, there is a lot of unnecessary minor omissions, which we don't have to take into account. Then there will be so much of not scandalous cross-examination, but cross-examination which turns out to be irrelevant. What is the color of that vase? What is the color of this broom, etc., etc.? How big was it? Where were you placed? All of those things. The appreciation also must be with sensitivity. The child who is under trauma of a very heinous offense has to depose as to what happened when that offense took place. Even our adults cannot do that. I used to have an exercise with the judges when I used to have physical hearings and my workshops, and I used to show them a picture. And I used to turn the picture from left to right in my class and then ask them questions. Many questions were wrong. Many questions were right. And I used to tell them that, you see, you are not a child. You are not under any trauma. I have shown you the picture just 2 minutes ago. You are professionals. Even then, some answers are wrong. One judge had told me, "Madam, I will not ever forget your shock treatment." So this is how the sensitivity has to be so important, and that becomes the substance of this kind of legislation for recording and appreciation of evidence. And of course, if we come to the conclusion that there is no offense created, we acquit, it's fine, okay. But if there is a conviction, then sentencing must be proper, fine must be enough, fine plus compensation is now required. Compensation by the government, let us say under the Manudharya scheme, as in Maharashtra and other states. Compensation even from the trafficker or the accused, if the accused is in a sound position, and rehabilitation. If the child comes with the parents, there is no question. But if the child doesn't have parents, if she was neglected, if he was neglected, it's a case of pedophilia, then rehabilitation is a must. Now the judicial conduct, the sensitivity. Court climate and courtroom conduct. Special courts which are ITPA courts and POCSO courts. Special courts necessarily not, but substantively meant by women who will understand, to whom the child can speak more effortlessly, more comfortably. This is under section 28. Priority in disposal. Now, if a court takes up all the cases, then the court can prioritize. Like when I took up those cases, I prioritized because I was taking so many different types of cases of adults also. But if there is a POCSO case, and then if you have to prioritize, how would you prioritize? Those generally judges take up those cases of 363, 376 because they are small cases and they can get their disposals. Now, that is not a sensitive practice. But you can prioritize and find out that, oh, this is a case which I think from the reading of the charge sheet that there is a real sexual offense. There is trafficking, there is sexual abuse, there is aggravated penetrative sexual abuse, whatever. Prioritize that. Put it on board. And nobody can or should say no. If an advocate is always allowed to appear for the defense, but he is not allowed to, and he should not delay the proceedings and take needless adjournments. So priority has to be maintained, but not in the case of statutory rape. Put them aside, and you see that then there will be fewer cases which require priority, and those cases are the ones which require the greatest justice to be done to them. So then, for those cases, the judge must give fixed dates and fixed time. The schools are of half days, so children can come in the afternoon session or in the morning session. But that case must be on that day, and it must be taken up and essentially finished. Okay. Then there is a fixed period. Now, under section 35, we have got 30 days, and nobody records everything in 30 days. Child statement only is required to be recorded. And if you are going to prioritize your matters, then at least for those real sexual offenses, those things can definitely be done within 30 days. And nobody can take objection. And those cases which are statutory rape cases, where you find that there is this 17-year-old girl living with a 20-year-old boy, and she wants to get married, and she's just wanting to delay it, and she becomes 18 and she can get married. Let her get married. Don't prioritize that matter. Don't appear. And even the lawyers can contribute if they are sensitive. They can say that there is this kind of a matter. Please, let us take it that way. Okay? So all can be sensitive. Then there is contact with court officials. Some NGOs bring the child to court before the evidence has to be recorded, just before, to just show what is the court proceedings. This is a very sound practice. There is no law which bars it. So, you know, they know that there are those kind of, there's so much of crowd, then there is this court there, somebody is shouting, oh, they may shout at me also. See, this is the prosecutor. He's going to ask me questions. This is the court official. And the child gets some kind of security. Then, of course, there should be no contact with the accused. So it must be seen that a child, when the matter is kept specially for the evidence, is kept at a particular time on a particular day, the court officials know, take the child, quietly keep the child in one corner so that the accused can not be brought before the child. And then, of course, the court will take over. So then there is courtroom conduct. And we say, this must be a child-friendly atmosphere. How do we have a child-friendly atmosphere? It's very important to know how. So we record evidence. Now we say evidence in camera. What is evidence in camera? You please open the dictionary and then open a law dictionary. And you will find in Black's Law Dictionary and in other dictionaries, in camera is a place within a focused place like a chamber. So now judges' chambers are the real in-camera trials. I was told by one of the judges that, ma'am, when we said that I'll hold the trial in chambers, the advocate started shouting that no, the law says in camera, it doesn't say in chambers. You cannot do that, it is illegal. I said, next time you tell the lawyer, please open the dictionary and see the meaning. Now, no one somehow has understood the true meaning of in-camera trial. We describe in-camera trial as a trial in which all the redundant people are thrown out of the court door is closed, and one case goes on. I am sorry, that is completely wrong. If it is said by any court, even of the Supreme Court, it is completely wrong. And I will tell you why. Now, when I gave you that impact and the fear that is for the child, the impact, the disbelief, the helplessness, etc., and more so the fear, please understand, whom will the child fear the most? I would have liked you to respond to me, but there is no time. So I will only tell you. Naturally, the child will fear the accused the most. The child will also fear the lawyer of the accused. The child will fear the judge who is sitting right on top there. The child will fear the police before whom the statement has been recorded and God knows what he has told the child. The child will also fear the prosecutor because he's going to now ask questions the way the police had asked him questions. and the child will fear perhaps the court officials. Will the child fear a bystander? No. If the child is left all alone, the child feels, I am the only one here, and all these are the people whom I fear. Because in an in-camera trial, you will have the accused, the lawyer of the accused, the judge, the prosecutor, the court officials, the police. That's all. So the child feels completely alone and lonely. That is not the purpose of an in-camera trial. And that is not why even the Supreme Court must say, hold that in-camera trial. Now let us take our position to understand and to have empathy with the child for that sympathy. We are going on an empty, barren road in the middle of the night, wearing, if we are a woman, a necklace, if we are a man, a Rolex watch, because we have come out of a wedding. Somebody is there, we feel, and we fear there is a robber. Will we fear this when there are many, many people walking with us? No. We fear this because we are alone, that robber may overpower us. That is the fear that a child has. And that must be assuaged. And therefore, we must have child-friendly atmosphere by an in-camera trial, which must be held in a focused place like a chamber. All right. Now I will tell you how I held the in-camera trial in a chamber and not in my court. And this was in about 2001, 2, 3, somewhere like that, when POCSO was not in the making, when we were still discussing and arguing about the fact that a POCSO must come into our system. So there was a case of child sexual abuse. I was appalled when I read the papers. I decided to hold it in the chamber. I told my court staff, who was very, very excellent staff I had, luckily and only because of that, like Chief Justice Ramana has said, he did everything because of teamwork. So I did everything also because of teamwork. I was only the captain of my team and my team worked very well. So I decided, I told them we are going to do this for that child on that day. Now I've given that date and time. So they said, yes, ma'am. They got the computer in my chamber. My steno was going to come on that computer. I told my Sharistadar that I will come in the afternoon because that's when the child could come. And I will call out, you call out the matter. And as soon as you call out the matter and the appearances are taken, I will come back to my chamber. Don't tell this to anyone. Take care of the child in the meantime. See that she does not see the accused. That's all. They said, yes, ma'am, we'll do that. I went to the court. They gave the appearances. They were ready. I had made it very, very clear. I said, yes, please come to my chamber. We will record the evidence. And I got up and I walked out. I did not wait for opposition and attacks and all of those things. I said, let them do that in my chamber if at all. I had told her, send the girl, and immediately after 1 minute or 2 minutes, send both of the advocates, as usual. I had kept everything in my chamber. The computer was to my right, 3 chairs here, 1 chair to the left, 1 stool behind, and of course, some other place for my other staff. Now, as soon as I went, I disrobed. I took out my band and gown. I sat on my chair, which was on the same level as the child. I hardly did this, the child came in. All I did was I took out my hand and I told her, Beta, मुझे तेरी story सुनने की है आज, हाँ? Last time अभी आपको सब बोल देने का है, okay? So she told me, हाँ, madam, okay. In the meantime, both the lawyers came, the prosecutor and the defense lawyer. I told them, sit here, sit here. So they were flanking the child. I called the mother of the child, whose evidence was already recorded, because she was the complainant. I made her sit on my left side. Then I called the accused. And I had told my peon, call him quietly, take him, let him sit right behind the child. So he was brought in and he came and he sat down. I had told my peon, you be at the door and the policeman also must be at the door. When I want the muddemal, it has to be given. And they were all at attention. And my steno was already there. And I told both the lawyers, I said, she is right next to you. Please ask questions. very softly, quietly. Okay, there is no need to shout because she is a child. Please remember, we have children and our children don't grow up like this child, if at all this is correct. And I told the prosecutor, I don't want the identification first. I want it last. Somehow in Bombay, they do the identification in paragraph 1. I don't know why. It should come in paragraph last of the evidence in chief that all this happened and this is the man who did it or woman who did it. Anyway, so this proceeded, some raising of tempo. I said I will call off the cross-examination, which I was of course not going to do, but I had to keep them under control. And I said, otherwise I will ask her, you ask me in English, etc., etc. I took from Gurmeet Singh and Sakshi and I extended it further and everything. And the evidence went on. She gave me the evidence. And then she had to identify. So I said, Acha beta bolo, abhi ye kisne kiya hai? Because that's what the prosecutor asked. She is telling me, Auntie, वो अंकल नहीं है इधर. I said, नहीं ऐसा कैसे हो सकता है? आप देखो, आप उठो, इधर उधर देखो, चलो, उठो. So she got up. She turned round because she saw her there, and there was the accused. He had his right of hearing. He had his right of understanding. He heard the trial. He saw the trial. This girl had the right to be heard. She was heard. Now she became completely ashen. She was white. And she waited for 1 minute just there. I was seeing her back sort of, and she turned the face. And she did not say anything. So I thought that she will not tell me. And I was just deciding in my mind that I will say that I've seen her demeanor. And her demeanor shows that this person was the accused. Because her case was his identification. And that time, she pointed her thumb towards herself, in a fist. And she's telling me, Auntie, yehi wo uncle hai. So I took down that way. And I said, now you cross-examine. And he started asking various questions, several of them. I said, no intimidating questions, no scandalous questions, no irrelevant questions. But of course, several irrelevant questions I allowed because I knew there was nothing else to ask otherwise. So it went on till quite late in the evening, but it went on peacefully. And the advocate asked various things and we finished the cross-examination. And I told her, see, I promised you, that you will tell me last time. Now you don't ever have to come to court. So she said, thank you, Auntie, and she went. Now this was trial in camera. Now we have got video recordings also, and now it is growing so simple, so cheap. So we can do that way also. One judge had kept the child in between, the accused in between two cupboards, so that the child cannot see the accused in the courtroom. I think that was a very sound thing, a very new thing. Somehow we have got now some rules that should not be done. I don't know why, but this was a good thing to do. But if you have only a curtain where the accused is sitting, that is completely frivolous because the child knows that the accused is right behind the curtain. If you have a one-way mirror like they have in England, then it's okay because the child doesn't know. Only we know that there is a one-way mirror and the accused can hear the trial, see the trial, but the victim cannot see the accused. So this is how we have the atmosphere, the courtroom conduct. Then there is a specific place for all. So as I told you, I gave you all the specific places. The child can easily see her mother. The steno is on my side. I don't look at the steno. I kept on looking at the child and the accused him all the time. So the accused did not misbehave. He could have misbehaved. He could have made some sound or something, and the child may have felt anything, but that didn't happen, luckily, in that matter. So there was a specific place for all, including for the policeman who must be at the door and not near the child. Then no intimidating questions that we find. Then recording of evidence by the court. So if there is anything, now of course everything can be recorded by the court because it is under POCSO. But otherwise also, if there was any time when a court felt that this is intimidating upon any witness, The court can always say, you tell me in English, I will tell her in the vernacular. Period. And rest time and breaks, which comes from our judge-made law also, and now under Section 33. So this all together makes the substantive, sensitive, child-friendly law for the children. And therefore, I would say, hear those who cannot shout. Listen to those who cannot speak. That is justice. And we would have children like this. They are like your children and my children, but everybody's children should be like that. Thank you.
Yeah. Thank you, ma'am. You have taken the wide spectrum of the law, which we all thought would have been. Ma'am, just stop that screen sharing.
Yes, I will stop. Is it stopped now?
Yeah.
Okay. Can you see me?
Yeah.
Okay.
This is. This is one of the suggestions, he says, Mr. K.K. Rao. Transportation of girls for trafficking, boys for child labor to other countries. What is the way to stop that?
Well, that is a social issue, not a legal issue. See, everyone is a trafficker. There are various people who work together. One is the transporter. So that is the person who really takes the child and brings the child into the brothel or anywhere else, you know. We cannot stop anyone to conduct a business. We do not know whether when he is going to conduct the business, it is going to be sort of offensive under our criminal law or not. But we can have our children in such a way that they may not be taken away by the transporters. How do we do that? One is we have fewer children whom we can take care of. I would say the population explosion is really the greatest problem that way, you know, and especially family size. Population explosion within the family, where the children are neglected. Children are poor, there is poverty, there is unemployment, no education, no employment opportunities. Then children are taken away by those transporters. We cannot have a law, don't take the children away, because he'll say, I'm not taking the children away. So we have to work, law and society goes together. I'm writing a book now on this aspect, and on the various gender perspectives which come up in law and in society, and how they can be mingled together, merged together.
We only have this question. And what the saying says, kindly share the notes. I will ask ma'am, and ma'am has already been kind enough to share the notes.
Yes, sure. Take it. I'll send it to you.
Yes.
Send it.
So before we end for the day today, I will ask Shalini ma'am to have her a flip, or how does she conclude with that of the today's part 2, part 1 and part 2. So it was quite encouraging for the mind to have different perspectives. Over to you, ma'am.
Thank you, Vikas. And it was really an excellent presentation, Justice Roshan, and that is what the comment and chat box is also saying. This is the law which requires sensitive implementation, application, and operation. Otherwise, the law is not going to have any help. And that is where we require the judges like Justice Roshan Dalvi, who is, as I told you in the previous introduction itself, has always adopted the innovative ways of making the justice real for the victims. Otherwise, it is merely a pursuit of justice, and that is really made, achievable because of the ways he had found out even before the act came into effect. So it was really in that way an eye-opener or something, which we want all the judges to really implement these methods, these ways of doing the substantive justice. As she has opened the session with the quotation of Kailash Satyarthi, justice for every child, how to achieve it. And that is the way she has shown it. And I'm really thankful to her for that. I'm also thankful to Vikas for making this platform available for the 2 sessions on the subject of justice to child, and especially in the light of the POCSO Act. So thank you to everyone, and thanks to the participants also who have actively, got engaged in the entire interaction and discussion on this of importance for every child, for every parent, for every citizen, and for every future citizen also. So thanks to everyone.
Thank you.
Thank you everyone for joining us, and because of your participation, the resource persons we can always bring, because we come to know what type of sessions are taken. We will ask ma'ams to take sessions on our procedural law so that people can understand on more in detail in some of the subjects. I will connect them later on. And thank you to all those who have connected with us. Everyone stay safe, stay blessed. Namaskar. Thank you.
Namaste. Thank you.